Good afternoon, everyone, and thank you for joining us today. Join our event on contesting artificial intelligence explanation in the UK. This is an event co-organized by the British Centre of International Comparative Law and the School of Law at King's College London. We thought it was timely to discuss this topic today, as legal explanation of artificial intelligence are shaping its future. For example, the General Data Protection Regulation includes a right to explanation that secures a limited opening of the algorithm black box, potentially enabling challenges to automated decision by data subject. But data protection is far from the only field in which automated decision systems, their developers and implementers have duties to explain themselves. For example, the law variously requires explanation as to whether application of this technology may play a part in discriminatory treatment or abuses of market power, negligence, material harms, and excessive state or private surveillance. What remains unclear, we think, is whether the explanation currently being generated are sufficient to maintain justice and the rule of law in the context of rapid social and economic transformation. And this is the topic of our discussion today. This event considers whether now may be a good time to engage UK policymakers on the benefits of including relevant civil society representatives and legal practitioners in a more constructive way. And so we have today with us currently leading contestation, leading figures in the area of contestation action across key sectors to discuss with you their experience of using the law to obtain explanation of data-driven decision-making, as well as to reflect on shared policy priority and how to pursue them. So we opened the question chat box already, so please use it to interact with our panelists today, who are Rosa, an international and UK human rights and public law solicitors, who led Foxglove legal team in their algorithmic justice cases. Ravi Nak, the Law Society 2019 Human Rights Lawyer of the Year and co-founder of the data rights agency AWO. Robin Allen, Queen's Counsel at Cloister, who specializes in employment equality and human rights law. Conor McCarthy, a barrister based at Moncton Chambers in London. Maxwell, a researcher at the Public Law Project. Lilian Edwards, Professor of Law, Innovation and Society at Newcastle University Law School. And Perry Keller, an Associate Professor in Media and Information Law at King's College London. And of course, our wonderful chair, Professor Julia Black, LSE Strategic Director of Innovation and also currently Fellow at the British Academy, but about to become President of the British Academy this July. Among all the other things, she wrote an influential article published last year in the European Journal of Law and Technology on regulating artificial intelligence and machine learning, which I will now also link in the chat. Please, over to you, Julia.
Great, thank you so much, Irene, and welcome everybody to our session today. So to say this is an important issue is a masterly understatement. I think we can all see that although AI and machine learning has actually been around for longer than we may think, that its impact and its importance in areas that are absolutely central to the way that we run our societies and we govern and are governed is becoming increasingly critical. It's difficult to contest that. So one of the things that the key question, however, that we want to explore today, as Irene was saying, is the role of law in contesting and in a way holding to account the use of AI and machine learning in different situations, different social contexts, social, economic and political contexts. And so we have a large panel today who are very much looking forward to hearing their thoughts on these questions. And each one of them is going to offer from their own perspectives and experience thoughts on whether or not our law currently provides sufficient ground for contesting AI explanations, whether or not current provision varies across sectors or whether this is a general problem, that arises across different sectors in different ways. And building on that and using examples, what constructive suggestions each may have for how law should develop to support the contestation of AI explanations, and how we can get these recognised perhaps more effectively in current policy debates. So not small issues. We do have some time. We have an hour and a half, but I'm sure that time is going to race past. As Irene said, if you could pose questions in the Q&A function, we'll endeavour to pick up as many of those as we possibly can, but without making any promises. We will try and answer as many as we possibly can, but obviously it depends on the complexity of your question, which I'm sure will be brilliant. So to kick us off, however, I'm going to start straight away in the interest of time, and ask Rosa if she would start us off on this conversation. Rosa, over to you.
Hi there, thank you very much for inviting me to talk at this event. So we've each been given about 6 minutes to try and answer these enormous questions. So here's my attempt. I guess to step back a minute and talk a little bit about why Corey, Martha and I set up Foxglove. It felt like this was an area in general that really was lacking a bit of litigation and conflict. There were lots and lots of different ethical panels. There were lots of kind of soft law guidance and policies and different advisory internal boards that have been set up in various different companies. And also there was some things that were happening at kind of inside government departments as well. But what it felt like it was missing was really litigation and some arguments before the judiciary. And so what we've been trying to do and what we feel is possible, even with the existing laws, which clearly, and I'm sure others will speak very eloquently about this, there are some limitations to, but actually what we've been trying to do is to win before the judges the fact that all of the public law obligations and standards that have built up over the years and are in very, very cherished part of our legal system, that they clearly must apply to all of the kind of data-driven and computer-assisted decision-making that is now happening within government. And I thought I would talk you through a little bit about a case that we took with JCWI, which was about an algorithm that was being used by the Home Office and had been used for about 5 years without anyone really being aware or having any knowledge of it, although obviously probably millions of people being affected by it, and talk through how that case came about, and maybe some of the lessons to learn from it in terms of how the difficulties in bringing some of these cases forward, and what we need to all look out for as kind of practitioners and people who are keen to make sure the law is used as effectively as possible in this area. So the case with JCWI, we came to learn about this algorithm through a very short piece in the Financial Times, and then through a fortunate conversation we had with someone who used to work at the Home Office, who revealed to us and made clear to us that there was an algorithm being used in relation to visa applications, and also that nationality was one of the criteria that was being used in order to determine what they considered the risk of the applicants who were making visa applications to the UK. And so when we learned about this, and I have to say, I think if we hadn't had that one FT journalist and also this one individual who used to be at the Home Office talk to us, I'm not convinced we would have been able to get the case off the ground, because I think without that level of disclosure and transparency, which is definitely lacking in lots and lots of different government departments still about how they're using data-driven decisions, I think this case would have been very, very difficult to get off the ground. But anyway, having fortunately learned about these, nationality criteria, we then challenged it by way of a judicial review, and we challenged it on kind of bog standard public law principles of the equality law, and also requesting kind of different transparency obligations as well. And we said that this in a way was a kind of updated version of the case that had been taken to the Supreme Court many years before in terms of Roma. There was a particular Roma rights NGO who took a case under the Discrimination Act about the discrimination that were being faced by Romani gypsies at Prague airport. And we said, look, this is in essence a kind of, this is an AI technology based, very, very similar example where the Home Office is basically scrutinizing and treating people differently on the basis of their nationality. So in relation to the algorithm, what happened is that if you were an individual who happened to be on the list of nations that they considered to be, risky nations, which that list was never actually disclosed, it was always redacted, then you were considered and almost certainly put into what was called the red pile. So people were ranked red, orange, red, amber and green. And that meant that you would have a caseworker look over your application very, very carefully and with an increased level of scrutiny. Whereas if you were put into the green pile, then you weren't. So there was clearly a difference of approach, a difference of kind of scrutiny that was placed on individuals simply because of the nation, the nationality trait and characteristic that they had. That's my timer telling me I've gone over already. So we challenged that under the Equality Act, and we ended up issuing proceedings. We tried to persuade them to give in before issuing proceedings, but they didn't. But shortly after issuing proceedings, they then gave in completely and agreed to withdraw the use of the algorithm in its entirety and go away and redesign and reconsider how and in what way they could use an algorithm or technology to assist in their visa application process. So that, I guess, is a good use of it was a kind of successful use of the law, but as I kind of hinted at the beginning, I think it was only really brought about and possible because somebody in essence kind of leaked what was happening in the Home Office. And I think there needs to be a really, really greater push, both through litigation and other ways, to try and get better transparency about what in fact is happening. Because although there's lots of legislation there that is requiring transparency, the reality is that it's not happening. And so we need to certainly, I think, take more public law challenges in relation to that. I'm sorry for going over, Julia, I'll stop talking.
But that's fascinating, absolutely fascinating. I'm going to ask actually Ravi now to give his perspective, because you work in the area of data rights and technology. So Ravi, why don't you take over, as it were?
Thank you, everyone, for having me here today. It's great to be part of this fantastic panel and to be with such a great audience as well. So my name is Ravi Nak. I'm from the data rights agency called AWO, and we are set up to bring cases about technology rights and how we empower individuals over that kind of technology. In a similar way to Foxglove, we work closely with Foxglove on a series of cases. And as part of that, when I was invited to be here today, the title of the talk gave me a bit of pause for thought, because the title is about challenging or contesting AI explanations. And the normal focus of a lot of our work, public law practices, or from our data rights work, is about challenging outcomes or decisions. And I think maybe the title is a symptom of this black box society that we found ourselves in, and Frank Pasquale has written so eloquently about. And a thread of that logic is, as Rosa was saying, about knowing and understanding what's going on behind the scenes and under the hood of the machine, so to speak. It's questions of transparency. And this rings true throughout the Data Protection Act, the data protection regime. The transparency obligations and access rights that individuals have include the right to know, and the obligations on data controllers to tell people if they are subjected to automated decision making. That right to object and not be subjected to such decisions in particular circumstances. And this need for transparency over decision making is a real regular feature of a number of our cases. And it's not just transparency for the sake of transparency as an end result, but transparency to try to then understand how a decision was come to and challenge that decision and that outcome. And it's often fighting for transparency, trying to challenge or get transparency that leads you to then get further concrete results. I think the highest profile example of where we tried to do that in practice is our case against Cambridge Analytica. It's quite a zeitgeisty case. I'm sure most people on the audience know about this case, but the way we applied the law was twofold. Firstly, trying to challenge the profiling of people on their political opinions. But for us to properly do that, to understand the automation behind that, we had to say, what are you doing here? And on one level of success, we could say to the company, we are entitled to access to data, and we got some access to data. And that access showed us that there was some automated decision-making going on and allowed us to start to put together the steps towards challenging the decisions that were being made and the profiling that was occurring. Conversely, the company folded before we got a chance to properly test the law and say that these are the confines of political profiling. It shows the limits of some of the law. Another example is the case of Michael Segalov against the Chief Constable of Sussex Police. And this is an example which goes to another part of the title of this discussion, which is, what is AI? What we're often talking about with the cases we're bringing, because the law naturally challenges decisions that are made historically, you're almost chasing the tail of developing technology. And a lot of the challenges we bring now are about quite rudimentary technology. You know, we're not talking about really sophisticated minority report type algorithms. We're talking often about Excel sheets being used by public authorities to try to steer decision making with yes, no type outcomes. And in this case, there was an individual who, for reasons best known to himself, wanted to go to the Labour Party conference. Michael Segalov in 2017 wanted to go to be a journalist to report on what was happening at the Labour Party conference. And he was denied access. And the police wouldn't tell him why. And it turned out that he was refused his accreditation to go because he had been labelled an extreme left-wing activist for reporting on protests. And we were able to challenge the fairness of the decision-making following chasing the tail of trying to get transparency. I think that's a really good example of how you need to get transparency and fight for transparency to be able to fight the outcome. So I can see in the work we're doing that the law has a lot of room to maneuver and reach and challenge a lot of these decisions and the outcomes that are there. But there definitely are gaps. There are gaps, for example, in understanding societal issues that are going on beyond the individual. And for example, understanding in the political context, who's behind an advert. That type of thing doesn't really come into play when you're talking about database decision making. I hope that's a helpful background to what the work we're doing and where we are. I look forward to having a discussion about this all moving forward.
That's brilliant. Thank you, Ravi, and thank you so much for sharing those different experiences. A number of things that we can be picking up there, and I think what you were saying there about the time lag in particular in relation to law, and I think what we might be starting to come up is the relative roles of public and private enforcement as well, as we start sort of pursuing our conversation. But Robin, could I turn to you next? You specialise in employment equality and human rights law, and are closely involved in this debate, which we're on discriminatory technology. Could you give us your experience and perspective? Thank you.
Yes, sure. Can you hear me okay? Can you just give me a thumbs up? You can hear me? Yeah,
absolutely.
That's good. Okay, lovely. Thank you. Right, well, a little bit about me very shortly. Together with a colleague in my chambers cloisters in London, D Masters, we set up a consultancy on AI law back in 2018. We have a hub called the AI Law Hub with lots of information and blogs and so on it. And we've been very closely involved in the developing work on regulation. So I'm just going to turn my picture off because then I think you may be able to hear me better. I'll just see how that goes. In 2019, we were asked to do a report for Equinet, that's the trade body for all the equality authorities across the Council of Europe, so not just the EU27, which we published early last year and which has been referenced in various different papers. We then started working with the Trade Union Congress in the summer of last year, and when they were looking at the way AI worked in the workplace, and help them prepare what's called the worker experience report. And in March this year, we will publish our report on the legal implications of AI in the workplace. We've also, in the course of last year, been asked by the Council of Europe to write a training program for regulators to work out what regulatory rights and tools they've currently got. And that's regulators at the moment, and that's involved working with the Centre for Data Ethics and Innovation. So that's a very quick bit of background about the kind of work that we've been doing. We were asked to just say a little bit about some cases that we've been involved in, and some of this is blogging work and some of it is actual work we're closely doing. There's just one very simple case I wanted to mention right at the outset. We're very well aware from the work we've done with the TUC how much the pandemic has advanced the use of AI systems in the workplace. So one case, for instance, we're currently involved with was a redundancy selection program that operated in the summer, in which the selection proceeded on a basis of using two different metrics. One was known performance metrics by sales figures that employees had succeeded in achieving. And the other, and this is the interesting bit, is that all the employees, because they couldn't be remotely seen, were required to undertake an online automated HireView interview. And our clients were selected for redundancy, notwithstanding good sales performance metrics, but because the HireView interview scored them down. Of course, questions asked in the course of the proceedings about the HireView interview, and all the employer could say was it looked at 11,000 odd data points in the course of the interview, 5-minute interview, and your clients did not score well enough for us to choose them. So it's a fascinating example of absolutely no transparency at all, a justification that will be advanced that the system had to be used because of the pandemic, but begs many questions about who actually took the decision. Was it the machine, or was it the individual, or some combination? All of which may or may not come out depending on whether the case is settled or fought. So, classic example of what's actually happening. I can talk about other cases that are going on, but this issue of transparency is really important. And there are two things that we've been looking at very closely at the AI Law Hub in relation to that. First of all, the efficacy of Article 22 of what we used to call the GDPR, now is the UK GDPR. And secondly, the principles of transparency required, particularly by discrimination law. And just a couple of things I wanted to say about that, and we can develop it in discussion. We are very firmly of the view that Article 22 is inadequate in the current context. I just wanted to quote a little piece from the European Data Protection Board's own commentary on the effectiveness of Article 22. What it is currently saying is that it does not require detail of the code that is involved. It's just all it involves is a requirement that the data controller provide so-called meaningful information about the logic, not a complex explanation. Now, quite what that means remains to be resolved. In the discrimination context, we've got well-established principles in European law, going back to cases such as Danfoss on an obligation to provide transparency and for inferences to be drawn if transparency is not given. But the Court of Justice, in a case called Meister, has said that you can't actually get discovery in order to secure transparency. All the law does is say that if there isn't full transparency, the inferences about the system may be drawn by the court. We think this is an area of law that will have to be developed quite considerably. It's quite interesting that there's a lot of different things going on around that, which we can discuss in due course. Bearing in mind the Uber decision last week might be worth, or earlier this week, when was it? Monday, I think, saying that there is a member of parliament the European Parliament who's put forward a draft directive suggesting that there should be much greater transparency in European law. And of course, we look forward to see what the outtake will be from the European Commission's white paper last year in its proposals for legislation in April. So there's just a few opening points for the discussion. There's much more on our website about the work that we've done.
That's marvelous. Thank you so much, Robin. And I can see this theme of transparency is one which we're going to have to absolutely return to in different ways. And we already have questions coming in on that as well. But Conor, could we turn to you next, please? So your work encompasses public law, civil law, claims, international law, complex disputes, etc., and particularly in the area of competition or data protection, etc. So from your perspective, how do you see law being used in the context of the use of AI? Thank you.
Thanks, Julia. So first of all, thank you again for inviting me to speak on this panel, and it's very interesting to hear the contributions so far, of course, touching on the issue of transparency. Now, there's three questions really that we've been asked to address, and I want to try to address each of those in turn. So the first issue really is to draw some examples of the challenges, either successful or unsuccessful, in relation to the use of the law to obtain greater transparency in relation to artificial intelligence applications. And what I want to do is to give an example of a recent case that, in fact, Rosa and I have been working on, an area that we've been working on in the last year or so, and then to use that to explore how essentially as a lawyer one would advise clients in this area in order to seek to bring a challenge or to seek to obtain some kind of remedy. So the example I think that perhaps illustrates this best is in the area of not strictly data protection, but in the area of export control in relation to surveillance equipment and surveillance technology. It's an issue which Rosa and I have been working on for some time with a number of clients. And in this context, one of the real challenges, so I'll present this hypothetically for present purposes, given that it's an ongoing matter, but essentially the scenario is where one has a client, which is an NGO, and the concern of the client is that surveillance equipment and technology, potentially involving algorithms, potentially involving AI, but also broader forms of software and technology are being used and exported from the United Kingdom to other jurisdictions throughout the world. Now the test, this is called dual use equipment because it applies both to military and civilian purpose. It can be applied for both civilian and military purposes. And there's a legal test, a legal arrangement, which has to be adhered to in relation to this equipment. And that legal system is that the key test is that the equipment must not be used where there's a clear risk that it might be used, must not be exported where there's a clear risk that it might be used in the serious violation of human rights or of international humanitarian law. Now, the key problem from a client's point of view is, well, what exactly is this technology doing, and how is it working in practice? And this is really raises this problem of transparency. The particular problem for a client who wishes to explore whether the law is being adhered to in this area is really relates to four things. First of all, these decisions are being made by officials based effectively on self-certification by the technology companies who are producing this technology. There's fairly limited means for officials to go behind what they're being told. The categories in some respects are relatively broadly defined and might not fully articulate the precise capabilities of their technology in various ways which may engage with human rights concerns. Thirdly, the technology is dynamic and adaptable. So technology can be changed potentially by the end user. And in the context of AI, of course, there's a particular dimension where sometimes the technology itself, black box technology is sometimes referred to, but it's dynamic and can itself adapt and change. And then, of course, perhaps the most fundamental problem in this area is that of commercial secrecy. So it's very, very difficult. One requires a great deal of expertise, but also it's very difficult to find out from a commercial point of view precisely what this technology is and is being exported. And one has to fall back on these categories that are used to publicize what the technology is purported to do on a self-certification basis. So immediately you can see that all of this. These decisions are immediately shrouded in a great deal of secrecy and lack of transparency in this particular context. And so then so essentially that's the scenario I want to paint. And then I suppose the question is, well, how as a claimant or as a lawyer can one address this situation? What tools does one have at one's disposal in order to deal with that kind of scenario if you're advising a client? And I use this just to explore the question of the sufficiency of the law in this context. So I suppose the first avenue that one would have is FOIA and in a related context, perhaps the environmental information regulations. Now this system essentially really won't in all likelihood provide an effective means for a claimant to find out exactly what this equipment is being used for. The first problem with FOIA is, of course, it's very slow. A challenge decision can take 1.5 years to produce a determination. But perhaps more importantly, the key point is that in FOIA, one's only entitled to access to recorded information. If information isn't by a public authority recorded, then it exists in useful recorded form, then FOIA will provide only a very limited means of obtaining information as to precisely what this technology is doing. There are, of course, a whole range of exceptions to FOIA as well, including commercial confidentiality. So that will be a further impediment to using FOIA to obtain information in this context. So FOIA, whilst it is, obviously a useful general framework, in truth won't provide a useful means for a potential claimant in that scenario to obtain information and transparency as to what's going on in relation to this, this technology, and particularly in relation to AI. It's also worth noting that, of course, FOIA doesn't impose a positive obligation on a public authority to produce an explanation in a sense where none actually exists. It needs to be in recorded form. So again, it's deficient. The other perhaps more useful tool, if one has a proper basis for saying that there's a concern as to illegality, is the duty of candor. Duty of candor would, of course, enable a claimant to write to a public authority and to elicit an explanation as to precisely what technology is being exported and the purposes it's being used for. It's a useful tool, but of course one has to trigger it, be at the point at which you can reasonably say there's illegality. So it's not a useful tool in the context of asking the first question as to just what is going on. In the context of private litigation, of course, the duty of candor and FOIA don't apply at all, because they only assist in relation to public authorities. And one would have to fall back on the CPR and pre-action disclosure and so forth, which again is expensive, and in reality for claimants that aren't well resourced, that won't provide a useful tool to obtain information as to precisely what's going on. So I suppose just sketching out that broad framework in light of that scenario I presented, the reality is that there are tools available certainly for claimants to obtain further information in the context of AI, in the context of technology. That's precisely what technology is doing, but that framework is limited to the extent to which there are tools that have to be used really quite carefully by the lawyers involved. The other issue, I suppose, that's related that we've been asked to address is whether the problems of transparency are sector specific or whether it's a general problem. Well, I think the first set of observations were addressed to the general position. I think there's no doubt that the issues of transparency in AI and algorithms are undoubtedly sector specific. So just to give a very quick example, in the context of competition law, there are specific policy limitations and legal limitations on the sharing of algorithms. Clearly, a sharing of an algorithm between competitors could actually result in anti-competitive effects. For instance, if the algorithm was used in setting prices or determining market behavior, that could constitute a form of impermissible collusion. So, and of course, the algorithms in many contexts will be commercially secretive. So just to use competition law as an example, it's clearly necessary to have a specific framework within which issues of transparency in relation to the use of artificial intelligence are considered. Just to note in relation to that, in the United States, there is the Office of Technology Research and Investigation, which has been set up, which plays a role alongside the Department of Justice in examining, it does a whole range of things, but one of those things is to examine the use of algorithms and technology and to provide advice and guidance in relation to that to the DOJ, as I understand it, in relation to investigations, and has the resources to do that. And so just by way of, I suppose, final concluding observations in terms of, what are the problems? Well, I think at a general level, one of the problems is that there are relatively few legal tools that one can use outside the data protection context to obtain, as a private litigant, to obtain transparency, that fight for transparency, which Ravi talked about. Often in different contexts, one's frankly reliant on regulators. I think, just going back to my point about resources and institutions, I think there is a real role for, from a broader policy point of view, for regulators and institutions to be well resourced, to have the expertise in-house and to have the staff and the available resources in order to understand precisely what algorithms in different contexts are able to do.
That's excellent. Thank you, Conor. That's given us a really good insight, particularly into various elements in the commercial market. As you say, it's very difficult, particularly in that export market, but more generally in relation to getting information out on that from those private players. Jack, could I turn to you next? Because you focus particularly on how technology is changing the way that government makes decisions about people and the channels by which they can be challenged. Would you like to give us your experience and perspectives? Thanks.
Thanks very much, Julia, and thanks to everyone for having me here and putting on this great event today. So I'm a researcher at the Public Law Project, which is a legal charity, people don't know, based in London, focused on promoting access to justice and promoting fair and lawful public decision-making. So my research, our sort of experience is focused on the public sector. So I'll sort of speak to that today. I think Ravi made a couple of points that really hit home for me about the questions that arise both in the context of today's discussion in terms of both getting an explanation for a decision and then doing something using that explanation to contest a decision in some way, maybe because the explanation is insufficient to justify the outcome. I think it's important to think about how the law deals with both those problems, both the access to the explanation and then what you do with it, what you can do with it. So in terms of addressing the first issue we've been asked, successful and unsuccessful use of law to get and test explanations of AI. The successful case briefly is a case called Sava. It was decided in 2010, and I wasn't involved in this, I've just sort of come across it in my research. It concerned care budgets. And this wasn't an example of AI in the fully fledged sense. And I think recent reports have said that, at least in the public sector, fully fledged AI is still relatively early stage. There are some test cases, but most of the use of automation and data-driven technology are slightly slightly more level, as Ravi mentioned. But the use of sort of algorithmic decision making at issue in SAVA was a mathematical model core system, which was used to convert an assessment of a person's needs into a monetary figure that could then be paid to them for their community care. And Mrs. Sava was a disabled person with a number of serious health problems. She disagreed with the authority's calculation of her personal budget and sought judicial review. And one of the grounds of her challenge was that the authority hadn't provided her with reasons for calculation of her budget. It hadn't told her what this model had done to get from the assessment of her needs to the monetary figure. And this argument was accepted by the Court of Appeal. They said that fairness in that circumstance required the authority to tell Mrs. Sava how the decision had been reached. And they noted particularly the importance of providing explanation for enabling her to understand and challenge the decision, whether by way of complaint to the local authority or by way of litigation. And they talked a bit about what adequate disclosure or explanation or transparency would require. They said, the authority should publish this model on its website, but also provide an explanation to her of how the decision had been reached in her particular case. So this was an application of long-standing administrative law principles around procedural fairness context, and it shows how these very well-established common law concepts can be adapted to more data-driven decision-making. And another more recent decision along the same vein, decided in 2018, a case called Ames, concerned the use of models to calculate legal aid budgets. And again, the refusal to disclose the model was held to be an error of law. Just briefly touching on a successful case in which there were difficulties in obtaining an explanation of data-driven decision-making, and even when the explanation was obtained, it didn't really help address the underlying harm. There was a long-running saga that people may be familiar with, M&M Office beginning in 2014, which revolved around English language testing for people applying for various visas. In 2014, the BBC revealed evidence of cheating in the administration of these tests, particularly involving a particular test provider. Home Office was very troubled by this evidence and asked ETS to assess, that was the test provider, to assess all the tests that it had administered over the previous 2 to 3 years, which added up to about 60,000 tests to determine whether there'd been cheating in each case. The test provider used an automated voice recognition system to assess the recorded portion of the test to determine whether a person had cheated. It concluded through this method that virtually every test of the 60,000 was suspicious. And the Home Office then used this evidence to take action against tens of thousands of people who were found to have cheated or supposed to have cheated on their tests. That meant cancelling their leave to be in the UK. Some people were taken into detention and some people were deported. Now, an initial issue in these cases was, how was this decision made? What was the technology that was used? And what were the inputs to it? What was the output? So the initial question was a lack of an explanation of how this testing had been, that formed the basis of the Home Office decision-making had happened. And the private test provider was initially very reluctant to disclose any information about that. So they didn't disclose the recordings that had been used, and they also didn't disclose the actual voice recognition algorithm that had been used either, neither to the students who were affected by the decisions, not even to the Home Office on grounds of commercial confidentiality. So that was an immediate hurdle for people to overcome, which made it very difficult to challenge a decision without having the information about how the claim that they had cheated had been reached. But then after about a year or two, a degree of greater transparency began to emerge, both through some disclosure of some information by the Home Office and by the private testing company. And I think what that illustrated is that even though at that stage, people who had been affected by these decisions had a better understanding of what was the model that had been used and what were the inputs and outputs, it still didn't necessarily address the problems that had affected them. And there's sort of a range of reasons for that. But one reason is that it emerged that one big problem was not necessarily the voice recognition algorithm itself and how it had determined whether someone had cheated or not, but actually the data integrity of the inputs, the recordings that had been fed into the system, and whether those had been kept securely and not subject to any interference or careless kind of confusion. And so understanding, sort of having an explanation of how the algorithm worked was a part of the puzzle, but it didn't necessarily answer all the questions that needed to be answered to work out both whether the correct decision had been made in each case about whether a particular student had cheated, but also whether the decision was lawful as well. And so those cases are still making their way through courts and tribunals as claimants and lawyers and judges are trying to unpick whether the Home Office decisions based on this automated voice recognition analysis were accurate and were lawful. So very briefly, just turning to whether the law provides sufficient grounds for contesting our explanations, focusing for present purposes on administrative law and public law principles. I think there, as various people have mentioned, there's plenty of room for these principles to be developed and applied to both enabling access to our explanations and contesting those explanations. So principles like procedural fairness and like the emerging public law principle of transparency. But I think, as Rosa mentioned, this jurisprudence is still quite underdeveloped. There have not been enough cases brought yet for courts and litigants to really figure out exactly what these principles require. And I think as the voice recognition exam cases demonstrate, the process of obtaining and contesting an explanation once the decision has been made is expensive and time consuming. And it's very difficult for people who have been affected by a government decision, particularly one as radical as potentially removing their status to be in the UK, to spend the time and the money to engage with and challenge this decision. So it suggests that we need to be thinking further upstream about how can systems be designed in a way that makes it easy to get an explanation, and we need to maybe make more policy choices about where automation and AI is used in the first place and where it may maybe not be appropriate to be used. I'll leave it there, and maybe we can get into a discussion of other sort of policy suggestions and legal frameworks in the Q&A. But I'll put the citations to the cases I mentioned in the chat too. Thanks very much.
That's brilliant. Thank you, Jack. And I think you're right. We'll definitely have to come back to this issue of where private law litigation fits within a menu of different types of regulatory approaches. It's clearly a key element, but whether it's necessary or whether it's sufficient is something I think we need to come back to. Lilian, can I turn to you next? So you work in areas of internet law, IP, artificial and AI, and you've been involved in law and AI since 1985, I think. So it's definitely been with this on the journey. So can you just give us your perspective, perhaps picking up issues in relation to IP or taking this wherever you'd like to go in terms of the different sectors?
I've given up IP. I've given up IP, not just for Lent, but for life. So I don't know how that was left on the list. I ran a copyright centre for 4 years. That's enough for anybody. Time off for good behaviour.
All the IP lawyers listening, don't worry, there will be another section for you.
So I don't really know what I'm doing here after listening to all my esteemed colleagues, actually, because I am neither a solicitor nor a barrister, nor have I even been a public law researcher working on particular cases. And I did say, I think, to Irene that by the time it got to me, everyone would have mentioned all the good examples. And so it has prevailed. So I guess the only thing left for me to do really is to probably make some outrageous statements, which is what you have the pure academic on for. So I'll do that. So I will first of all say that one of the themes, I suppose, of my own work over the last 4 or 5 years is that transparency is overrated. I'm really here just channeling Ravi, what he was saying, which is that, and I'm always channeling Ravi, of course, that you know, there is no point in looking at transparency as a remedy in itself. Transparency is a means to an end, and it's a very limited means to an end. I mean, again, this has come out through what people have been saying, but for the average person, transparency as a remedy implies subsequent agency. In a condition of a level playing field. And this is invariably exactly not what you have. So if you're lucky enough to be an Uber driver who's got James Farrow gunning for you, or to be someone representing immigrants who gets Ravi on side, then, you know, wow, the sky's the limit. But that is sadly not most people. So I worry, particularly in the private sector, that there is, I think, in the public perception, or at least in the quasi-academic public policy sector, our perception that transparency is a goal in itself and that it will solve the problems of the world, when it won't. I suppose I'm scarred here a bit by the debate around the right to an explanation, which was very, very long and heated and prevalent around about 2016, at least in my rarefied world, which was the question indeed of whether the GDPR, I'm horrified to discover I'm now meant to call it the UK GDPR. I am never going to do that. That the General Data Protection Regulation, that it had introduced some kind of right to an explanation in respect of solely automated decisions in Article 22. And I wrote a very long article on that with Michael Veal. The jury is still out on that one because we still haven't got any case law. But the main point was that Article 22 was amazingly limited. You know, I always call back on the Yorkshire joke here. You know, if you were going to have a right to an explanation of AI, I wouldn't start from here. In that it only applied to solely automated decisions. It only applied to them when they'd been made under certain lawful grounds. You had to know what a decision was, which was not altogether clear. There are various stages of classification that might not be regarded as decisions, but are very important. And most notably, I think that it had to have legal or significant effect. And, you know, at the time, maybe now we're clearer on that, but at the time there was a great dubiety whether advertising or even the offer of goods and services would be described as having significant effect. It clearly didn't have legal effect. I think now, post-Cambridge Analytica, I think that we would agree, I hope, that targeted advertising, particularly in the political context, has significant effect. And only when you'd worked your way through this morass of exceptions and special cases did you get anywhere near a right to an explanation, which was itself, again, another glorious feature of the GDPR, not actually found in the main text in the articles, which you might see as being of binding effect on member states, but only in the recitals, in recital 71. Which, you know, again, there is difference between different member states as to whether the recitals have binding effect or whether they are merely interpretative, helpful guidelines. So the main point to pick out of all that, I suppose, is that very, very, very few AI decisions, and maybe I should come back to that point about AI, are solely automated, right? And so again, we have another huge debate going on, not at all resolved anywhere, I think, as to what the human involvement has to be or not be before you can regard it as substantively a solely automated decision. You know, if a score is given to a judge to make a recommendation as to bail or probation, the judge clearly is there. How much do they have to do? How much do they have to not rubber stamp before it will be regarded as solely automated, right? So there's this huge grayness there. And I think what Robin was referring to is, in fact, what looks much more useful than Article 22 is the general provisions about transparency and information earlier on in the GDPR, notably in Article 15H, that say that you've got a right, just as you've got a right, your subject access right to get access to the data about you, you've got a right to, unquote, meaningful information about the logic of processing. I think I'm quoting that right. I haven't got that article open. Again, as Robin said, we don't know what meaningful information is. So that's my little academic piece. To go back to being outrageous, I think one problem I've already said is, well, there's vagueness, there's the lack of agency once you've got transparency. An example there that I've just been looking up while we've been talking actually is the current Uber case that was, decided, great, fantastic decision last week. Was it last week? And I remember actually being involved talking to people about whether we could use Article 22 there to find out more about the Uber algorithm, because it's often unclear to drivers why they're being penalized, why they're not getting jobs, why they're only getting jobs at bad times of the day, etc. I am not sure what's happened to that challenge. What I think is interesting as a rhetorical point is that the Uber drivers have really got what they wanted. They've got employment rights without having to go through that process of invoking Article 22 or Article 15. So as in almost every case that's been discussed here, what has saved the day, as it were, has not been data protection law, even though we've talked so much about it. It's been straight public law, it's been labor law, it's been discrimination law, right? As Conor said, there still leaves, I think, a big lacuna in many private law, non-public law areas. And there we do fall back on the job of the regulator. So I agree very much with the point that was stressed there, that if we don't have regulators, not just in data protection, but in other areas such as insurance, credit, loans, all sorts of things like that, then we won't get justice, we won't get explanations, and we won't get justice. But the kind of final 2 points maybe I think I've got here is transparency and challenge don't in the end get you to the place where you can say our technology is bad for our society, right? And I think that's something we have to think about systemic remedies, of which the most extreme is a ban. Now that sounds incredibly illiberal, but I've just written down a list of AI techniques that where you don't just want to know how it works, you don't just want to know why they're using it, you want it to stop. That's a completely different remedy. And on this, to-do list, you might put police use of face recognition, employer use of emotional recognition, emotional face recognition, which is pure snake oil and is being increasingly used in online recruitment. You know, look at this person's face. Do they look trustworthy? Do they look honest? Do they look like they'd be a good shelf stacker in Sainsbury's, right? There is more and more and more of this. Is an area I am working in. Targeted advertising, which of course Ravi can, turn me upside down and talk about. Does it really help that we know how they do it? What we want is them not to do it. And I'm sure I've written down another one here that I can't read. I can't read my own handwriting. E-proctoring, which is very, very big right now, again, in the online educational experience. Do we think that e-proctoring, do we just want an explanation of why it told you were cheating when you tried to go to the toilet? Or do we want it to stop? And I would argue the latter. So the last academic point I'll throw in is look at a couple of places you wouldn't expect to look. So I think maybe Robin mentioned just en passant the Digital Services Act. Was that what you were referring to? So a couple of decisions which never seem to get challenged for transparency, which is also interesting. Content moderation. Content moderation is one of the most obvious and prevalent solely automated decisions going on in our society right now. Also deplatforming, which has been very, topical. So deplatforming is not just for Trump. Deplatforming is for lots of people, ordinary people who might be on a site. Perhaps their livelihood depends on being on that site on Facebook, and they might get thrown off it, Amazon Marketplace, and not know why. So again, transparency might help there, but what is likely to give you, I think, more usable transparency there might be the guarantees that we're promised in the Digital Services Act about transparency against platforms. And notably, I think they use the phrase knowing the parameters of how the decision was made to take down content or filter content. Yeah. So let's keep a watching brief on that one. And the final thing I'll throw in there is that the online safety bill in the UK gets a very bad rep. Having taught it last week and now knowing momentarily more about it than I ever thought I would, I wonder if there isn't an opportunity there in relation particularly to legal but harmful content, to try to get some structural requirements into these codes of conduct they're talking about, which might give us not only better transparency, but better systems, actually better systems, as Lorna Woods keeps talking about, safe by design. So we need to think about how we make all these algorithms fair by design, ab initio, rather than waiting for, you know, all of you guys who are so wonderful to come in and help us post factum. Okay, so that's my privacy by design, fair by design, safe by design. I'll stop there.
Fantastic, Lilian. Thank you so much. Perry, I'm now going to turn to you for the you have the unenviable position of coming last at the end of what's been an absolute tour de force by all the panelists so far. So I'm going to, but I'm sure you can rise to that challenge. So why don't you give us your perspectives, and then we will turn to Q&A. Thank you.
Thank you. Thank you very much, Julia. It's been really fascinating to listen to everybody. And what I'd like to do is provide a framework to put everything together, which the other panelists can reject later if it doesn't fit for them. But this really comes out of the research that Archie Drake and I have been doing, and led to this great cooperation with the British Institute of International and Comparative Law on this. So the way we can look at this and think about everything that's been said today is to think about two big trajectories that are clashing. And one is a long-running trajectory, which we could call participatory transparency and accountability. And that really involves ideas about participatory democracy and exploring some of the legal avenues for public interest assertion of transparency, and very much as was said by Lilian and some of the others today, is transparency and that very rickety bridge from transparency to accountability. But this is a long-running trajectory, and it is broadened over time. So it really began with civil litigation, and then with private law actions, then judicial review. And then we saw other developments like freedom of information law adding in. And then more recently, data protection law has brought other transparency tools, particularly subject access requests. Now, to link all of those together is to reflect also that this trajectory is one where it's one of pragmatism, innovation, putting things together in innovative ways to achieve transparency and potentially accountability, whether it's in public for public authorities or much harder to do with private actors. So that innovation continues. There's a lot of recent work, of course, is going on around class actions, representative actions. And that's a way you can see that the efforts of individuals, groups, lawyers, working with them is pushing this trajectory forward. But it's also one where time, resources, and coordination are in extreme scarcity. So it falters continually, but nonetheless, it's quite broad. So we have that trajectory. It's also one that has historically always been subject to severe structural and doctrinal constraints, because this kind of public activism through law imposes serious burdens, compliance burdens, and also risks of disclosure of legitimately confidential information. So it is, these legal avenues are not wide open. They're structured to limit, and also doctrinally, judges have often been quite reluctant to allow some of this innovation. So you can see right now, a very good example is the Lloyd and Google case before the Supreme Court, deciding some key questions about representative actions, and to what extent the Court of Appeals more relaxed approach will be permitted. So that's that one innovation, one trajectory. The other trajectory is shorter, but hugely powerful, and that is the trajectory of introducing automated decision-making, AI, into the governmental and commercial spheres. And in this trajectory is really about governance both about principles, ethical principles, and then filtering into law. It's marked by a great deal of paternalism. This short, powerful trajectory has been one in which there's not been a lot of direct public participation in determining what are the appropriate benefits, but also what are the harms. So the defining of the harms has been one which has been to some extent at a remove. Now that's always true, but in this case, things have moved very fast, and consequently, the defining of harms, and with it, what are the duties, rights, and remedies associated with those harms, is one which has been distant from public debate and public participation. So to bring those together and explain, partly give a framework for what we've been talking about today, it's to say now A has hit B. This long-running trajectory about public interest participation and transparency and accountability has hit this other trajectory about the governance of AI and automated decision making. And in that, the first trajectory is faltering. As we can see today, there's been particular innovative developments, uses of public law principles in interesting ways, but some aspects, as already remarked on today, and I'll move quickly through this, are things like FOI, such an interesting, though problematic and limited remedy, but an interesting one for obtaining transparency in relation to public authorities. As you know, it carries no right to demand an explanation. And without that, if you're only able to obtain information which is already held in some recorded form by a public authority, it really is not designed for the era of AI. Similarly, subject access requests, those for the large part, except for this, as Lilian was discussing, the Article 22 rather than Article 15 right of access, there's some rights of explanation largely as yet undefined, but in many respects, exercising a subject access request is to access existing information. So that is one way in which this is faltering, because the design tools of transparency don't fit some of the deep needs to probe into automated decision making. But secondarily, if you move beyond those falling away, so FOI is no longer as useful as well, we still have private law litigation, civil litigation, and judicial review with tools of discovery. And within those, although limited by problems such as commercial confidentiality and trade secrets, and the limitations that are sometimes present in obtaining that information even through discovery, there is at least that power to require some explanation. But all of that turns on, as I kind of wind things together, what are the rights you're seeking to enforce? What remedy are you seeking? And those in relation to AI and automated decision making go back to this point that we've not seen as broad a debate as we needed to about these harms and how we're defining it. So data protection law, which has been thrust so much to the forefront, excessively so, has been one in which we are being provided with a range of rights, but we are being told very specifically, no, this is what it's for, those are your interests, those are your rights, and you can enforce them in these ways. But for example, there's an enormous debate, growing debate, about whether the harms in relation to intrusion into privacy and disclosure of personal data, sharing of personal data and processing and profiling is a collective harm. It's a societal one. This excessive focus on the individual is not allowing us to reach and begin to even discuss, let alone resolve, that societal or collective issue. And my point here is that whilst we have certain litigation tools, they are not in some ways designed appropriately. And so to wind up and sort of go forward, well, you know, drawing on what some of the other people have said, and also from our research, is we need to think about who the intermediaries are. What are the independent bodies that can act and give really meaningful transparency in ways, but also are keyed into issues of accountability? But part of that has to be, in my view, and in our project view, is opening up and saying, well, where does the kind of participatory democracy element in this run, and how does that key into really all the way back to how do we define the harms? Okay, well, that's all I got.
That's brilliant. Thank you so much, Perry, and a great way to round us off as well, to provide us with those two kind of more meta frameworks to be thinking about these debates. So listen, we've got not very long left, and we have more questions than we have minutes left, basically, within the session. So what I'm going to ask each of the panelists to do in turn is to just, in the order that they spoke, just to pick out one of the questions that really is compelling for them, or is most relevant for them, and to answer that, and in doing so to pick up on other people's contributions. I don't mind if you all come up and you all hone down on the same question, because I think you'll probably have different insights. Rosa, can I go for you first then, please?
Yeah, of course. So there's a question to me directly, which I'll answer, but also I wanted to pick up a little bit on what Lilian was saying about, and also Perry, because one of the things that Foxglove has started to kind of, I mean, we're still very anxious about the kind of fairness of the processes, but we also feel like in some ways, although it's important to continue to do that and ensure there's fairness, actually there isn't any kind of democratic mandate for any of the things that are currently happening within government. So we're now trying to use the law to force that sort of process to happen. So today, for an example, we've launched a case which is to do with a particular data deal that has been signed between to do with NHS data, which has been signed with a particularly delightful company called Palantir, who probably some of you may know, most famous for splitting up families on the Mexican-US border, and being run by somebody called Peter Thiel, who is one of Donald Trump's biggest supporters. So a slightly odd choice, you would think, potentially, for a partner in our NHS public health. And the case that we're trying to run, which is exactly trying to kind of step back and say, actually, no one has given the government permission or consent or any kind of democratic consent to the idea that any of these things should be happening. And so much of these different technologies and AI processes, data driven decision making, have come in without any of us, come in kind of without us noticing, or certainly speaking for myself. And so what we're trying to now do with the law is, in essence, force that debate to take place before anything like these sorts of deals are signed up to, or indeed new technologies are used. So Lilian very helpfully was mentioning all the kind of technologies which I think lots of us would feel should never be brought in, and actually fiddling with how they're being used feels like it's slightly missing the point. So we're now trying to use the law to create that debate. So we're arguing, for example, in the case of this data deal, which gives Palantir access to all of our health data, actually, in fact, that is not a lawful way of behaving. And actually, there are consultation obligations on the government before they bring in and before they even propose. At the moment, they're beginning to think through that this is a kind of use of our most personal, most sensitive medical data that the NHS holds on us all, that in fact, the government needs to come to us and ask whether that's in fact okay with us, and whether we have any views on it, and if they are going to enter into an agreement, what sort of conditions and limitations there should be in relation to the use of that data. So that feels like a really important focus, well, certainly from kind of our perspective at Foxglove, that the law does really need to turn to and start to grapple with in a way that feels there hasn't been quite enough of that to date. So I'm hoping that will change a bit.
Thank you, Rosa. I'm going to have to move on actually, because we've only got to get everybody in. I'll just have to restrict you to a couple of minutes each actually. So much more we could talk about. We could go on for many days, not just all this day. Ravi.
Thanks, Julia. Thanks, everyone. I am, like Julia says, because talk about this for days, but it's been great hearing all of the perspectives. So I just want to start by talking about some of the reach of the law as it stands that's still being tested, and why we need to support the work we're doing. So I'll leave aside public authority, but talk about private actors. So there are two principles in the data protection regime that we're pushing in cases that I think will make a significant difference. So firstly, the idea that data needs to be processed fairly. What does fairness mean? I mean, I'm sure all the public law practitioners here know how that applies, but if you start to apply the idea of fairness to private actors processing our data and using automated decisions, it's quite a powerful tool, and we're seeing some success with that in some of the work we're doing. Secondly, this idea that there is so much happening with automated decisions, and maybe sometimes not automated decisions, as Lilian rightly points out. Often we don't know what is happening with the data that's being collected and for what reason. And in the data protection regime, there's a very clear idea that data should be collected for specified and limited purposes and not to be used for other purposes. And a very clear example of how this gets misused is the idea of Google. What is Google? What do they collect data for, and what do they use that data for further purposes for? We are challenging Google. We're asking Google, who are you? What data do you collect for what reasons? And I think once you start to pick apart and allow people to say, I'm willing to give this data for this reason and not for others, that's quite a powerful tool. But there are limits. So for example, as I tried to say in my brief introduction, the data protection regime only applies between data subjects and data controllers. Often there's a gap between those two things, and there's a vacuum of accountability in that gap. Particularly, there might not be an agent over the technology being used. Google tried to argue that they were not, for example, a controller over Google search. That's a rudimentary system. With more sophisticated technology, you might find that kind of link start to fall apart. And that's an interesting thing that we need to start to think about. And I've written about this elsewhere, and I'll send a link to some of the writing on that. And then just finally, one of the interesting things that's being discussed by organizations like the Ada Lovelace Institute is the idea of algorithmic auditing. I think it's a really interesting idea. How might that work in practice would be really important. And finally, the deficit of automated decision-making, the idea of significant effects. It is really hard. There's no case law. You see the ICO, for example, taking a very different position on what an automated significant effect is from an automated decision, contrasted to the European Data Protection Board. There's quite a disconnect between those two things. It'll be really good to see some case law come on that. There's a bunch more stuff I could say, but I'll hand it back.
That's incredibly rich already. And for people there, links are to the cases, etc., are going into the chat box. So if you're just keeping an eye on the chat box, you'll see the links there. We can't see your questions in the chat box. They are in the Q&A, but brilliant. Robin.
Gosh, such a little time to talk about so much. Very quickly, the points that I wanted to make in response. First, I absolutely agree about some of the sort of raised eyebrows about whether the focus on transparency is completely apt. One of the things that we've been picking up in the work that we've been doing is a kind of higher level point than transparency, which I just want to mention, throw out there. We call it observability. There's an awful lot of unobserved use of AI systems. In the employment context, for instance, if you're a young person who is just out of education, you post your CV on a CV board on the net. It may be LinkedIn, it may be some other version like that. And you will get job offers based on AI systems that look across the net for it. What's going on is that you are also being rejected frequently. This is an example of unobserved use of AI systems, but there are many others. And we need to think about the observed and the unobserved as well as transparency together. So that's a short point, much more could be said about it. I think that the role that is being taken by litigation is really important because it tests the utility of the rules that we currently have. But I'm personally convinced that we need new and good and apt regulation. And this is a huge problem. It's a huge problem because the regulators currently are way behind the game. To my knowledge, for instance, the QCA, dealing with some of the issues we've just spoken about, have, I think, only one person directly working on it. CMA, Competition and Markets Authority, very similar. EHRC, the Equality and Human Rights Commission, are only just starting working on it. The ICO has done some useful work. Some of it has been criticized as not going far enough. The regulators are thinking a little bit in silos. One of the things we've been recommending, and I'm glad to say the CDI have been saying, is it's critical there's joined up work from the regulators. So that's all important. We certainly need a risk-based approach to all uses of AI, whether in the private or public sector. And it's going to be the role of government to work out how we approach that. Impact assessments have to happen, of course, on the GDPR front. They're not mandatory under the equality regime, but are often recommended. It's absolutely critical there's a joined up approach to that. Finally, one question: do panelists have concerns about governmental data sovereignty? And will the EU become another gatekeeper alongside the US and China? Answers as follows. One, I'd prefer the EU to do it than US and China for reasons which may be obvious. It is going to happen, I'm afraid, like that. There's no doubt about it. The EU market is the largest in the world, even with post-Brexit. And although they're slow to the game, they're thinking deeply about it and more comprehensively. What is much more worrying is the development of international trade rules. We've not said very much about this, but if you look at the moment, for instance, at the recent UK-Japan trade deal last November, or the Canada-US-Mexico trade deals, the protection of IP trade is being entrenched, and there's going to be conflicts arising from that. And it will only be resolved at the level, I'm afraid, of the kind of EU-US-China triangle. Now, that's a lot of points put very shortly and not developed, but that's me done.
Thank you so much. Now I realise we can only answer in bullet points at this stage of the proceedings. Okay, Conor, my turn to you.
Thanks. I just have a couple of quick thoughts just based on what other panelists have said. I think, first of all, I think it is helpful to, I think the comments which have placed transparency in context, and to think about it in context, and certainly from a practical perspective for many clients, it's undoubtedly the case that if they can see an outcome which they don't like, and often that will be the starting point for any client in litigation, if they see an outcome that they don't like, often it's possible to completely circumvent questions of transparency by focusing on the outcome and by challenging the outcome. And if you have a proper basis for saying that an outcome, whatever that outcome might be, whether it's an intrusion of privacy or self-preferencing in the context of abusive behavior in the context of competition or whatever, if you can see that outcome, and if that outcome can properly be said to be unlawful, then really one doesn't need to enter into detailed debates about transparency. I think transparency becomes important obviously in the context of where the process becomes critical to the legal challenge. And I think as a contextual point, it's important to keep that in mind. I think the other important thing that struck me is that there is clearly a big distinction here between public authorities and the obligations, the broader obligations that exist in public authorities and the position of private individuals. Just as a broader reflection, I think it's really quite difficult to see how one could develop a broader legal framework or principle of transparency by which individuals can obtain, a right to, or a system in which they can obtain transparency in relation to AI technology. It's always, I think, going to have to be done on a sector-specific basis because of the obvious constraints in different sectors on providing details of algorithms and so forth to private individuals, or detailed explanations in different contexts to private individuals. So I think it does have to be done on a sector specific basis, and I suppose that does tend to reinforce the point I think Lilian was making about maybe the legal focus ought to also be on the design of AI and legal frameworks to ensure that one doesn't need to get into processes, because the obligations are placed on those who design the AI technology to ensure that they stay within the relevant legal limits. So I suppose I would, as an overall thought, I would endorse that that way of viewing things.
Thank you. And Jack.
Thanks very much. Fascinating discussion. I'd just quickly like to touch on a question from Roman in the chat, which is talking about problems of definition. I think it's a really interesting and important question. And in a sense, some of the difficulties some of the other panelists have talked about with Article 22 illustrate the difficulties of reducing the concerns we have about algorithms and particularly explanations into some kind of statutory code or codified language, because there's always going to be a question of, well, we might have a case that concerns us that falls outside the express terms of that provision. So how do we define what is an algorithm, and how do we define what is an explanation if we're going to be codifying that? A couple of thoughts about that. I think one is that this shows that there is a role for more principled regulation, or the use of broad principles. So, data protection law obviously uses that as a tool. Public law, of administrative law, clearly uses that, and that's something that emerges in the cases that I talked about procedural fairness. There, the driving concern is about the values that are deeply embedded in public law about enabling people who are affected by government decisions to understand why they've been made and to challenge them in courts. And so the technical definition of whether something's an algorithm or not is sort of beside the point. If a court is going to actually give effect to those values, it'll be able to, or hopefully will be able to, without worrying too much about the technical definition. But the other point is if we are looking for more comprehensive regulation and potentially some kind of greater statutory regulation in this area, which I think there's a very good argument that we need, then there has been plenty of thinking about how that might be done in a way that doesn't leave us with difficult line drawing questions. So the Centre for Data Ethics and Innovation published a recent report on algorithmic bias, and that contained in a chapter on public sector transparency, quite a good summary of both the technical tools that are available to enable explanations to be given of machine learning algorithms, but also the other information that needs to be provided as well about where those algorithms fit in human decision-making processes, and the various tools such as impact assessments and other mechanisms that are being used to work out what information has to be disclosed. So there's plenty of thinking out there on that, and I don't think it's beyond us to be able to work out how that be put into some kind of codified and legally binding form that would be effective. Thanks very much.
Excellent, Jack. Thank you. Lilian.
Yeah, it's very, very interesting to hear what everyone's saying. I'll pick up on one point from the audience as a narrow point that I can say something about, which is someone's asking whether there's a role for data portability rather than a right to an explanation. I mean, that is something that we toyed with in the slave to the algorithm piece, and I think in a later piece. So the idea would be that you could get hold of your data from a platform, say like Fitbit or Google or whoever, or Zurich Insurance, and then run it through your own system at home, your own algorithm perhaps. Perhaps there could be a market of competing algorithms, and you could see whether the result came out more favorably to you. So I think the person in the audience was saying that that's what they were doing about telematics insurance in the connected car market, which is very interesting. I still think this is very much tinkering around at the edges, but it is always worth thinking about, the uses of the right to portability and also the right to be forgotten, the right to erasure. And we also hypothesize that you might be able to ask to try and get your data taken out, not only of a system, but of a trained model, which is a sort of interesting concept. Whether it gets you anywhere, I'm not sure. But mostly, I still think this is tinkering around at the edges, not least because something we haven't mentioned that's blatantly obvious. The GDPR scheme only applies to personal data. And a lot of these decisions on that Foxglove that Rosa was talking about are not just, if at all, about personal data. So I'm tempted to advertise just very briefly that the grant I'm on with BICL is going to look at data-driven decisions relating to public health in the pandemic emergency. And one of the things that we were brainstorming yesterday was, how do we know indeed that data-driven decisions that are crucial to our society, such as the decision to go into lockdown, when to go into lockdown, how to allocate restrictions around tiers, when to take the tiers down or up, how do we know that these decisions have been made correctly for some value of correctly? So all of these, I mean, because the way we live now, really, data is how we live now. Data-driven decisions are how we live now. So in a way, what we're doing is we're developing a new form of democratic participation, and that is a giant task. So I'm very glad to hear it mentioned. And I'll stop there.
Brilliant, thank you. Carrie, over to you for some closing thoughts.
Thank you, Julia. Just very quickly, as we're now out of time, but I just wanted to add in and sort of help to frame things up by saying, well, of course, one of the effects of Brexit on all of us were, regardless of what we thought during the process, is to tend to make us focus more on the UK in our thinking, and which is very helpful in terms of remedies and what's to be done. But the other side of this, and my point is that nonetheless, we have huge transborder data flows, and the kind of solutions that we need to think about and develop also need to be done with a very clear idea as to where the processing is being done, what legal regimes it's being done, whether in the rest of Europe, or for example, of course, in the United States, bringing Google back in, and even further afield from that. So that would be the thing I would just tuck in here at the end.
Excellent. Thank you. Listen, everybody, thank you so much to our panelists. Incredible depth and incredible breadth. Actually, we have covered an enormous amount. Necessarily, there's many more areas we can go into. Thank you so much for everybody who's participated. We tried to answer some of your questions. I realize there are more to be answered there, but that just means we never need another session. So thank you very much to the BICL and to King's for hosting us today. And yeah, I think we'll just have to say see you next time. There's more to talk about. Brilliant. Thank you so much, everybody. Goodbye.